The next case on the call of the docket is agenda number 11, case number 126507, Thomas Ittersagen versus Advocate Health and Hospitals Corporation. Mr. Todd Allen Smith.
Madam Chief Justice, members of the court, my name is Todd Smith on behalf of Tom Ittersagen, the plaintiff appellant in this case. This case is about the risk of bias on a jury and how it is dealt with that basic right of an unbiased jury. Here it's also, I believe, significantly about how the trial court and the appellate court came to believe an endowment, an equity endowment, an entity existed when it actually did not. It provided some separation in the trial court and the appellate court for purposes of determining whether there was direct relationship here. And in this case, that direct relationship exists. There was never an endowment at all, an endowment entity at all. The evidence in this case is overwhelming in that regard. There was a juror here who had a relationship, a direct relationship with the defendant advocate. I'm going to call them advocate because trial counsel for the defense used that term repeatedly. At page 1874, for example, of the record, she described something that she said, and when she heard about the note that was written by the juror, that everybody has a relation with advocate. As a result, I'm going to call them that throughout all of this because that's what the defense called them at trial. On the 7th day of an 11-day jury trial, Mr. Glascott, William Glascott, announced through a note to the court that he and his company had a business relationship with advocate, and that was the term that he used. He was left on the jury even though there was an alternate juror available. This was someone who declared he had a fiduciary relationship with advocate. Multiple times in the questioning in the transcript, and I would point the court to the record, 1880 through 1889 are the primary pages wherein you will see his multiple times that he acknowledges this fiduciary relationship.
Well, wait.
Yes, sir.
In the context of what he's talking about at the various times, advocate, we have advocate, the defendant, health systems, and then we have advocate, endowment, or whatever. He's in the context, he's referring to, when he's talking about a fiduciary duty, he's referring to the endowment and not to the defendant.
The endowment doesn't exist. There is no existing entity called an endowment.
Okay, let's say whether it exists or it doesn't exist, that he thought it existed, he being the juror. I mean, he was talking about advocate endowment during this colloquy with the judge.
So what he's speaking of, in our view, pretty clearly, is he's speaking of the investments of parent advocate. And if you accept judicial notice on this issue, you will see at page 12, I think it is, lines 11 through 13, this $6 billion that he spoke of that was the overall healthcare system endowment. You'll find that there. At the beginning of that year in 2018, they had about $5 billion. By the end of the year 2018, when this case was tried, they had a little over $7 billion. So during that year, they had about $6 billion. So when he calls out a $6 billion endowment, he's speaking of invested funds for the benefit of a not-for-profit. That's what he's speaking about. There was never an endowment. This is.
How do you take it?
Pardon me,
how do you apply judicial notice to what you're talking about?
Well, judicial notice is something capable of being declared, and of certainty, really. And what could be more certain than the sworn statement of this defendant with regard to their tax return under penalty of perjury? I mean, it's clear in terms of the factual ability of that to stand tall and stand as facts in this case. It was not available to us at the time of this trial in November of 18. It became available only when it was signed in November of 19.
Well, but there were prior years. I mean, this endowment wasn't created, or endowment, this wasn't created that year. I mean, this was an ongoing relationship between what we're calling the endowment and the defendant. Now, this happened on day 7 of an 11-day trial.
Yes.
So what you're saying is that your side could not have looked into this during the remaining 4 days, or thereafter, before the post-trial judgment motion was filed, to find some relationship between these two entities?
Well, what I'm suggesting is this. This happened on the morning of the 7th day at before 9:30, because I think you know that it was 9:30 from the transcript when they started to get. So what you had happen was they're thrown this note that morning, and they hear it's a business relationship that he has with Advocate, is what he says. So what they then found, that he describes a fiduciary duty relationship with them. So the next thing that Jason Williams, the plaintiff's lawyer, has to do is go out there. They're in the case in chief of the defense, and he has to cross-examine, once the direct happens, cross-examine those witnesses. They're in the middle of trial. The judge has made her determination that she's not going to release him for cause. She had an alternate available. What would be the need and urgency of keeping this juror when you could easily clear this up, when there was so much strong evidence of a relationship with this defendant? On the issue of the endowment, as I say, the plaintiff doesn't know that. The representations were made by defense counsel in this case, Your Honor, that indeed there was an endowment, that there was a separation that was described. And you can see the trial court, page 1882, immediately about 7 lines later, saying, well, does the endowment pay you in some way? As if you're paid by this investment that you have. She has clearly thought that now there is an entity. The appellate court did the same thing. The appellate court, in its determination, we did not meet our burden, decided this based upon the idea that there was this endowment entity that we hadn't connected to the medical group. So basically what we have, a non-existent endowment entity and a non-existent medical group. It's assumed name. The medical group is the big advocate. The endowment is the big advocate's money. So what you end up having is big advocate with their investments and big advocate with their DBA medical group. What happened was it was separated on the pages that I was going to talk to you about, 1882, where the defense counsel actually steps in and says, after Juror Glascott had said, I'm involved with the hospital's endowment. You said it's the hospital's endowment. Right. The Advocate Healthcare System endowment. He's talking about investments for the benefit of a not-for-profit. There is no endowment. But that's the vernacular. It's not the medical group that's here. So the separation begins, you see. This situation with the medical group, over here to the investments, it's not the medical group. No. The overall $6 billion endowment. If the court takes judicial notice of the 2018 tax return, the year, as I said, begins at $5 billion or so and ends at a little over $7 billion in terms of their investments. Same page, defense counsel makes the express statement, not a question, in front of and to the jury and with the court present, of course, and listening to this, the endowment people are separate from the medical group per se. Now, that's not a question. It's a statement by her introducing this idea that there's this separation. That's how it begins. That's how the trial court ends up thinking it's an entity. That's how the appellate court ends up thinking it's an entity. And then what happens, she says, then states, and you understand that this is Advocate Health and Hospitals medical group and one of its doctors, that's the defendants here. The word understands important because what the appellate court ends up doing. The appellate court was misled by this as well. At paragraph 62, they actually said this. It was Juror Glascott's understanding that the endowment is separate and apart from Advocate Medical. No, that wasn't his understanding. She had said that. She had said it's separate and per se.
How do we know what his understanding was?
Pardon me?
How do we know from the record what the juror's understanding was?
He said a number of times that he was a fiduciary to them, to Advocate. In the question that Mr. Williams asked, he said, "But you're a fiduciary to Advocate. And do you agree you're a fiduciary to Advocate?" or something to those words? And he said, "I do. Correct. I'm a fiduciary to Advocate." So this creation of an entity in that way, and if you look at the pages that I've cited, Your Honors, I think you'll see what I'm talking about. The court fell into it, the trial court fell into it 7 lines after those statements were made about the separation per se and so on page 1882. Does the endowment pay either of the defendants? She's believing they're getting payments or something. She interjects, the defense counsel does at 1883, not with a question, but that statement that I read, for further separation. That was the goal, to separate and suggest that, oh, these people aren't really related in some way. The salaries, she says, full-blown statement, nothing asked for, it's not a question. The salaries and compensation for the medical group come specifically from medical group operations. They do not come from any other endowment. So she's making this statement that this is all separate in some way. When in truth, Advocate Health and Hospital Corporation is the mothership. You have an endowment that doesn't exist. You have medical group that's a DBA of this entity at the top. It's all of their money, and he's a fiduciary directly to them.
Without the tax return, though, we don't know.
Pardon me?
Without the tax return, though, we don't know that, correct?
I think you do know it. I think you know it from his testimony.
From whose testimony?
Pardon me? Pardon me, his statements. Under oath, he's a juror. He swore twice as he became a juror, so his statements are sworn, and he says as much. He tries to clarify a couple of different times. The endowment raises money for the growth and expansion of the hospital system overall. They have a pool of money. Who's they? This endowment to grow the hospital system. He says, they have a pool of money that invests to grow the hospital system. I mean, it's all part of the same.
You're not asking us to change the Cole standard, right? The so direct standard. You're not asking us to change that, correct?
We cite Cole. We believe in Cole.
So you're saying that this meets that standard?
Absolutely.
Okay. I mean, if you look at 1887, the juror specifically asked, if the defendant wins or loses this case, is your financial compensation affected in any way? No. And then he's asked, do you have a fiduciary duty to either defendant here? No.
Yes, and at the very next question, Your Honor, what he says is, the court, do you have fiduciary? He says no. And what is your basis for saying that? Well, so one of the defendants, being Advocate, I guess, and then he's cut off. He's cut off. It says, and Mr. Williams first interrupts, and I think simply, as you can see, to clarify, Advocate Health and Hospital Corporation, and then the defense counsel says, wait, stop basically, wait, and then begins questioning him to divert attention to the general partnership that he worked with. The next question is, she tries to suggest that his fiduciary duty is only to the general partner. It says there's a general partner and there's a whole series, and she says, but the fiduciary obligation is to the general partnership and the growth of your company. Correct, but then he pushes back. He pushes back at this page twice on 1888. He says, I have a fiduciary responsibility to the endowment of Advocate. He's talking about their investments, not about an entity. We know that now. They've admitted that, page 41 of their, for the first time, page 41 of their response, they've admitted it. And then she goes on to say, right, but I have responsibility to all this is at lines 12 and 13 of 1888. And then he says, I have a fiduciary responsibility to all our investors, Advocate being one. I have a fiduciary responsibility to the endowment of Advocate. And on other pages, in response to questions about what he does, he says he oversees all of the new money investments that we make, which is Advocate's money. On page 1884, lines 3 through 5, which is Advocate's money. It goes into a pool. Sure, we get an asset management fee. You have a financial interest here with them handling that money. This is direct. Those management fees he testified or he's provided the information on, management fees support salaries, he's salaried, bonus, rent, keeps the lights on, he says. Basically their existence. That's how basic this is.
What do you say again is the direct evidence that the endowment and the Advocate Medical are intertwined, are part of the same entity?
Advocate endowment doesn't exist. Advocate that's investment money of parent advocate. It's in the tax return at page 12. The lower courts were misled about this in terms of that there was an entity, and then you have a tax return that shows you the money. If you were to, at this point, you'd have to believe, one would have to believe, that there's another advocate in this state, running hospitals in a health system, that has $6 billion to work with. Can you imagine the trade name infringement on that one in terms of advocates? And this is the one. This is what it is. And his answers, do you have a fiduciary duty to advocate at page 1886? I think I said page 14 earlier. It's 1884. It is 14 on my transcript. But you have a fiduciary duty to advocate. I do. Correct. He tries to clarify even further. I oversee all the new investments that we make, which is advocates' money. He talks about the financial interest. I mentioned the facts that, following up what Your Honor had, Justice Burke had indicated at 1887. He tried to clarify, so one of the defendants being advocate, I guess, and then gets interrupted. At 1888, he fights back. He actually clarifies, in my opinion, right, but we have fiduciary responsibility, all of our investors. It's advocate that's investing. He's talking about that $6 billion. In response to a question by defense counsel here, he actually connects the money. He said in response at 1888, lines 16 through 22, he says, she asks, in response to a question by defense counsel about this endowment, does he understand whether they have anything to do with malpractice or payment? He said, no, other than the endowment, he's referring back, their funds is what he said. He knows he's tied to these funds. The endowment, this overall $6 billion endowment, they own hospitals. He ties them directly to whoever owns the hospitals. The tax return shows that as well, that they are the parent of all of these hospitals.
So is the juror a master, servant, or steward, or counselor of the defendant?
Not a master, but a servant, a steward, a counselor? Absolutely. 1930, I don't think that was an exclusive list, but those are all fiduciaries as well. Servant, a fiduciary in character, but absolutely in terms of a steward, it's an old-time word, but it's someone who's a counselor, who's an advisor, who looks over property. That's a steward, and we fit that mold. Maybe on steroids. He's a fiduciary. He is a servant. He is a steward for them, and it's direct.
Are there varying degrees of being a fiduciary?
Well, I think if you are a fiduciary, you're a fiduciary. In other words, if you have, he announced he does have that, and he also said, I think it was page, let's see, page 1889, Your Honor, 1889. I think I've got that right. He says, I know generally we have fiduciary responsibilities. What I'm talking about is he at their firm. He talks about, that's why I read that, they discuss at their firm as financial advisors. There's a U.S. Supreme Court case, I think we cited, that someone with a fiduciary duty, as a matter of law, is an implied bias, if I've got that correct. But my point is simply, that's a question of law, but the fiduciary, I think, they clearly fall into that here, Your Honor.
Before your time is up,
Yes.
Can you briefly tell us what our standard of review is on this?
It's de novo. I could say that for a few reasons, a couple of reasons anyway. Giroux versus Klein, I think clearly lays that out for you. You have a question here of due process, a very fundamental fairness situation for this for this plaintiff, and for people similarly situated. Cole, I think, supports that as well. It starts out with of course, Naperville in 1930, where they're talking about you just don't go there in terms of someone who has this relationship. It's a question of law, and therefore de novo. Dating back to Aaron Burr, Chief Justice Marshall spoke to it when he said that you can't trust even when someone says they're unbiased and they'll follow the evidence. It's a matter of you can't do it. The law won't trust that.
Mr. Smith?
Thank you.
Thank you. Mr. Larson?
To make noise with this. Justices, counsel, may it please the court. I have to get my glasses. Plaintiff asked this court.
Please state your name, counsel.
I'm sorry, Robert Larson, L-A-R-S-E-N, on behalf of the defendants, appellees. Thank you, Your Honor. Plaintiff asked this court to dramatically expand the scope of circumstances under which implied bias may be invoked, and thereby dramatically restrict the discretion traditionally afforded trial judges to evaluate the credibility, bias, and demeanor of jurors. Defendants take no issue with the notion that implied bias may be appropriate in certain rare and exceptional circumstances involving direct relationships between jurors and parties. In those rare circumstances, jurors should still be questioned to determine if the nature of the relationship is such as to be disqualifying, rather than simply taking a talismanic word and saying that's enough to exclude someone.
It's your position, isn't it, that this is a question of a standard of review is abuse of discretion?
Yes, it is. No such relationship that would be absolutely disqualifying exists in this case. There's no case or statute in Illinois or anywhere else that applies the implied bias doctrine in a manner to merit overturning the jury's verdict in this case, where you're talking about an employee of a company that may or may not have a relationship with one of the parties, as opposed to a direct relationship between a juror or prospective juror and a direct party. The case law is very clear here that the plaintiff has the burden. They have to establish that the relationship at issue is of the rare type to require excusing the juror regardless of bias, or they have to establish bias. They've done neither here. Now, in order to make this argument, plaintiffs rely upon a bit of sleight of hand with misleading terms, misleading references, and misrepresentation of case law and statutes. I'll give them credit. First time today in 2 years of post-trial activities where I've heard that now apparently there was no endowment. Endowment didn't exist. It's all advocates' money, and this tax return, which doesn't mention endowments, somehow definitively proves that. Well, first of all, it wasn't defense counsel that used the term endowment first. It was Juror Glasgow. He's the one who stated it. He's the one who brought it up. But apparently counsel wants to disregard Juror Glasgow's statement. Apparently he doesn't know what it was he was working on, but plaintiff has a tax return that says otherwise. As Juror Glasgow was asked by the court, do you feel that you can stay neutral and unbiased? Actually, that's a little bit earlier than that. The court asked, what is the nature of your firm's relationship? And it says, so their hospital endowment invests in we're a private equity company that raises funds to invest in real estate. That was the first time the word endowment was used. And incidentally, the first time the word fiduciary was used when it was put in Juror Glasgow's mouth by plaintiff's counsel. He kept infusing the word fiduciary duty into the discussion. So this is what plaintiffs do, and as counsel indicated, he's going to use the word advocate generically as if there aren't multiple legal entities in the state of Illinois that bear that name, when in fact there are. Just during the course of this litigation, the term advocate, advocate endowment, advocate healthcare system endowment, Advocate Health and Hospitals Corporation, and Advocate Medical Group have come up. If one searches the Illinois Secretary of State's website, you'll also find separate legal entities entitled Advocate Charitable Foundation, Advocate Healthcare Network, Advocate Health Partners. There is no evidence to suggest which entity Juror Glasgow was referring to, but counsel has now conclusively determined, based upon a tax form that was introduced for the first time at the appellate court stage after the First District had already ruled against plaintiff, that somehow this definitively proves that there was no endowment, and Mr. Glasgow was apparently making up the term on his own.
The word advocate seemed to be used interchangeably in this colloquy between these four parties, the trial court, the two attorneys, and the juror. Did it cause any confusion?
I'm sure it did, Your Honor. I think the issue is that it was plaintiff's burden to establish that there was, in fact, this sort of a direct relationship, and not just saying, well, he used the word advocate, the defendant has the word advocate in their title, that's close enough. That isn't sufficient to establish this sort of direct relationship. And I think, frankly, if we go to that level, and if we simply generically refer to the term fiduciary and say that's enough, you now have to exclude the juror, because nobody is questioning, in this case, Judge Van Tine did a very thorough voir dire of this juror. She brought the juror back. She allowed both parties to question the juror at length. She did not just ask, as they refer to in some of the case law, rote or talismanic questions, can you be fair? She asked him to explain why. She asked him about his financial interest in the outcome of the litigation. It was very thorough. She observed him. She did what we ask judges to do. So if we just say fiduciary, what does the word fiduciary mean? We've been debating it throughout the course of the post-trial proceedings in this case. If we just throw that out and say, anytime the word fiduciary comes up, case over, you have to exclude the juror, that is where Illinois would stand alone amongst jurisdictions throughout the country. There is one case where one statute plaintiff was able to cite in all the cases they cited in their appendix where the word fiduciary used, and that was the Kansas Criminal Code. Kansas doesn't even use that word in their civil code. And there's a reason for that. It's too generic. We don't want this dramatic expansion where suddenly we're telling our trial judges, we know we've relied on you for 200 years to evaluate the credibility and demeanor of jurors. Now we're going to throw out talismanic words and say, these are excluded. And yet that's what plaintiff's counsel is asking this court to do. In addition to the use of the word advocate, plaintiff's counsel repeatedly refers to Juror Glasgow as a partner. Juror Glasgow was not a partner of anyone or anything. His corporation was a partner, one of, as he described it, perhaps 50 partners in one of their investment pools. And some entity that Juror Glasgow referred to as the Advocate Endowment was one of the investors. There is not a scintilla of evidence in this case that Juror Glasgow ever privately, one-on-one, advised the defendant, Advocate Health and Hospitals Corporation, about their investments. Plaintiff's counsel even went so far in their reply brief to state plaintiffs claimed that Juror Glasgow was hired by Advocate to invest Advocate's money. That is patently false. Advocate did not hire Juror Glasgow. Advocate gave some money to a company called Green Corp Investments, and they stuck it in a pool of other investments. And Juror Glasgow, who is not even a licensed financial advisor, oversaw a pool of money. There is no indication that he had the sort of one-on-one relationship with the defendant in this case that raises a concern about bias. Now, the court or plaintiff also says that cases and laws all over the country mandate removal. You can see from the brief, and I don't want to repeat everything that we've indicated there, but we went in great detail through the various statutes and cases cited by plaintiff where they evaluated this issue. And none of the mandate removal. What is the process that's been adopted in virtually every jurisdiction throughout the country? First, is there a relationship that is potentially disqualifying? Second, if that is the case, the court should bring the juror back and question them about it. so they can determine if it's the type of relationship that would raise the presumption of bias. If we just say, you say this word and bias is presumed and there's nothing further to discuss, then why do all these jurisdictions advise the trial court to question the juror? It should be very simple. You said fiduciary, we're all done here, go home. But that's not the way this works. It is plaintiff's burden to establish that keeping that juror on the jury would prejudice the plaintiff. Judge Van Tine, again, did a very thorough voir dire. She didn't use the sort of talismanic language that might be a problem. And that is what the other jurisdictions have said. If you have one of these categories of relationships, then you better question them to determine how close that relationship is. And then if there's any question about it, you better not just say, can you be fair? Yes. And that's the end of the story. You better dig a little deeper. Judge Van Tine dug a little deeper. There are also several things that are undeniably true about this case. Juror Glascott did not ever say that he owed a fiduciary duty directly to Advocate Health and Hospitals Corporation. He did not volunteer the word fiduciary. That was put in his mouth by plaintiff's counsel. He's not a financial advisor. Plaintiff's counsel even asked him, do you carry a Series 7 license? Do you have any sort of licensure as a financial advisor? He said, no, my company does. Plaintiff has not shown a connection between the endowment to which the juror refers and this defendant, except now we're being told for the first time there is no such thing as an endowment. The tax form plaintiff has attempted to inject into this case for the first time does not prove anything. It actually contradicts plaintiff's argument. Even in the most generous reading of the facts, there is no direct one-on-one advisory relationship between juror Glascott and anything that might be categorized as advocate. There has never been a discussion, Juror Glascott, did you call and sit down and meet with whoever's giving you this money and talk through how your money as opposed to this quote-unquote pool of money gets invested? Mr. Smith several times raised the quote saying at page 1884 of the record, which is advocate's money. They keep leaving off that part, which goes into a pool of money. They leave that off because it's not convenient for their argument. It's worthy of noting that this relationship, whatever it may have been, was so inconsequential that Juror Glascott didn't even think about or remember it until he got a LinkedIn request. And Juror Glascott did not hide anything. He volunteered this information. He approached the court and said, I want to be fair with you. I want you to understand that I just remembered this attenuated relationship. And then he was asked how it might impact him, whether it would impact his finances, whether it would impact his employment. He said his employers probably wouldn't even know about it. Now, if Green Court Investments was in fact a party to this litigation, sure. In that circumstance, Juror Glascott's relationship to Green Court condominiums would likely exclude him. If he was on staff at Advocate, or if he was a one-on-one financial advisor for Advocate Health and Hospitals Corporation, that would certainly raise the bar and raise more questions. Do you advise on legal matters? Does any relationship or involvement in a medical malpractice case impact how you would interact with this entity in investing their money in a pool of money? Those would be fair questions to ask. Still, I don't think it would be an automatic recusal. Automatic recusal should be in extraordinary circumstances where, for instance, the juror is actually the attorney for one of the parties. The jury is the son or daughter of one of the parties, things like that. We've analyzed the case of Marson versus Kipfer and Roach versus Springfield Clinic. And this court in Roach distinguished Marson from other cases. In Marson, the connection that led to the court finding the jurors should have been excused was that two jurors were actually active patients of the defendant physician in a malpractice case. Their relationship to the defendant had everything to do with why that defendant was in court. They even said, hey, if we got sick in the middle of this trial, I'm going to call him. I'm going to call the defendant. Well, of course, in that circumstance, there is bias. And yet, in Roach versus Springfield, this court said, you know what? It doesn't go so far as if it's the juror's spouse. That's not close enough. So the direct relationship is not something that we've manufactured. It's something this court has stuck to for a very long period of time. And even giving plaintiff every benefit of the doubt, let's assume that despite the utter absence of evidence that this was quote-unquote Advocate Health and Hospitals company's money. How much of it is invested in Green Court condominium, in Green Court investments? 1%? 2%? Small amount? It's a $6 billion sum that we've been talking about. Chances are that investment isn't the make or break for whatever entity is that was investing it. Certainly, Juror Glasgow did not say he was investing the entirety of this endowment. He did not give any legal advice. He did not give direct financial advice. So the issue here is public policy. Yes, there is a public policy interest in a fair and unbiased jury. However, there is also a public policy in upholding jurors' verdicts when they've been through a lengthy trial. Both parties have spent the time and money of presenting expert testimony, and 12 jurors have reached a definitive conclusion of whether or not the plaintiff has proven their case. That should not be discarded arbitrarily because of a word. We have trusted our courts throughout the history of this state. The trial judges, they are in the best position to observe and interact with the jurors to determine their demeanor and evaluate their credibility. With all due respect to the justices here, none of you have met Juror Glasgow. None of you had a chance to look into his eyes and say whether you believe him to be true. That's why we rely upon the trial court to do that analysis and that voir dire. There are also multiple cases, including U.S. v. Torres, which is cited, that talk about not creating a set of unreasonably restricting presumptions that jurors should be excused for cause, where the parties' rights are also protected by a showing of actual bias. In other words, don't throw the baby out with the bathwater. Judges are perfectly capable of evaluating credibility. Yes, there are those rare circumstances. My wife is somebody who's sitting on the jury where you have to exclude them. But those should be rare. They should remain rare. And they don't apply to the facts of this case. Where would the line be drawn if this court were to adopt plaintiff's determination as to what the standard would be? If one owns stock in a company, is that sufficient to disqualify the juror, even if they're a publicly traded company? Are patients of a hospital automatically to be excluded? I wonder whether any of the justices currently sitting on this court have ever been to an advocate hospital or an advocate-owned hospital. That is the nature of modern times in large hospital systems. But that's why we give the courts the discretion to evaluate this. Juror Glasgow was not Advocate Health and Hospital Corporation's master or servant. He oversaw a pool of money. He was not their steward. He provided no individual advice. He was not a counselor. He certainly was not an attorney. He was not a patient. He was not a family member or spouse. And plaintiff's counsel's representation is to the contrary. He certainly was not a business partner of anything referred to as advocate. And even those states, and we went through at great length the various states, that include language about circumstances under which the presumption exists, still say, trial court, once that comes up, question the juror, and then you decide whether or not they should be excluded. The legislature in the state of Illinois has not set forth a series of terms that say, if this comes up, this juror must be excluded. And part of the reason for that is these are vague terms. Allowing things such as fiduciary to dictate whether a juror should stay on the jury is going to open up a can of worms. We're already struggling to find adequate number of jurors to conduct these cases. If we're going to use vague terms to discard them or discard jury verdicts after a week and a half into a trial, that's going to create a problem. So if one looks at this, there's not a single case plaintiff has cited that's closely analogous to the facts of this case. This case is different. This is at most, a juror who was an employee of a company that, even assuming everything Mr. Smith said was true, had some of its money invested in one pool of money. There is no suggestion that he was a partner or direct fiduciary to Advocate itself instead of to this pool of money. That should not rise to the level of requiring the excusing of this juror. And there is no question, based upon the voir dire and questioning of the trial court, that he showed that he could and would be fair in this case. I've raised a couple of issues with respect to whether or not plaintiff actually procedurally perfected this case. We'll note just briefly for the record that plaintiff's counsel did not provide the voir dire, the pretrial voir dire to this court to evaluate what questions were asked of Juror Glasgow at the time and what his answers were. Certainly there's no suggestion that he misled anybody anywhere along the way. And I think that has to be taken into consideration as well. Briefly looking at the various cases that were cited, Naperville v. Worley, that's one case that plaintiff relies very heavily upon. There the juror, if you want to call that person a juror, the commissioner, actually worked for one of the entities being evaluated. He essentially worked for a party to the process. The school board's finances were being evaluated by him. And so that direct relationship, even in that 90-year-old case, that direct relationship is what was relevant. It was not an attenuated relationship such as we have here. Look at People v. Cole. There were all kinds of relationships. In a circumstance, in a murder case where the punishment was potentially capital murder, someone could lose their life or their lifelong freedom. The juror knew the prosecuting sheriff as a close friend. He discussed the case with him. He had spoken with the murder victim. He knew the state's attorney and the assistant state's attorney, and he knew the witnesses, and they still said, that's not enough, that doesn't meet the standard, and in fact, reversed the appellate court's overturning of the verdict. I see my time is up. I don't know if anyone has any questions.
Thank you, Mr. Harrison. Any questions?
Thank you, Justices.
Thank you. Mr. Smith?
Thank you, Your Honor. Don't confuse implied bias with actual bias. I heard argument about the idea of looking into someone's eyes or their demeanor and making a judgment like that. We're not really about that much at all. We believe we establish actual bias as well under these circumstances. There's a wide gap between what's being said here on the other side and what we see in this transcript in terms of this relationship that he announced he had. The idea that a man who is their chief investment officer is in some way disassociated with, has some distance from their relationship when they are partners and limited partners in money investing, I think is a huge stretch. The fact of the matter is, he announced you can't have a corporation that doesn't work through its own employees and officers. 50.11. This man is working for this company. So how does the company exercise its fiduciary responsibility if not through their officers? And that's 50.11. And he's the chief investment officer. He oversees the money, advocates' money, he said. And it sounds like they've almost reached the point where they're recognizing and acknowledging that that money goes into this pool, as if once it's in the pool, then it's no longer in some way associated with advocate. But I've never heard of such a situation. If the relationships of your money, you pay management fee based on the basis of that. You would get your results and your earnings based upon what you've put in versus somebody else in terms of this pool. That money is advocates' money, and their return on it is going to be advocates' money as well. We fit directly into Cole and Naperville. Questioning is more important in actual bias, where they are trying to discern whether this person's demeanor and what has happened there with this particular juror shows actual bias. Implies is, as was described as in Giroux, is if you have an unacceptable risk of bias. And here you do when you have this category of people. Once you show stewardship, servant, counselor, financial advisor, as a matter of law, financial advisors are fiduciaries versus brokers who work for commission. So as a result, I fail to see how this does not fit well within Cole and within Naperville. Let me take you to one more place here. When they finally acknowledged that there was no endowment, after the trial court had relied on that as an entity, and the appellate court clearly did, suggesting we had to show the Advocate Endowment connected to the medical group, they are the same thing. The money's there at Advocate Health and Hospitals. The medical group is a fictitious name. So it's Advocate Health and Hospitals. The direct relationship is right there. So when they had to admit at page 41 of their response that there is no endowment, separate or direct, the reason they do, page 3, line 10 of the tax return, they tell the IRS there's no money in any endowments, directly or indirectly through some sort of related company. And the definition of a related company from the IRS, you'll find, is basically subsidiaries. These subsidiaries they have listed in their tax return, they own, they control. That's the way that works. So page 18, why do you get page 18 from them, where they list these various other entities that have an advocate name? Only after the curtain has been pulled away to demonstrate that there's no endowment entity. They ask you to speculate now, well, maybe the endowment is associated with this other name. They ask you to take judicial notice of these others. And it's not just tongue-in-cheek. They cite a case for support for you taking judicial notice at page 18 of these other advocate entities. What they haven't told you, they said they are separate. That was on page 18. They said that they are not synonymous. What they didn't tell you is that they are related under the Internal Revenue Code. They are subsidiaries. They held that out for you because they don't have the thing they can hide behind anymore, this endowment entity. And what you have now is trying to have you speculate that these others might be the source of that endowment. There's one place where this $6 billion is, and that's with the main entity, the parent. You'll see this in this 800-page, if you accept judicial notice on this, you'll see in the 800 pages of tax return at page 263, you'll see the property where Tom Ittersagen was cared for. This AH&H owns that. You'll see all the hospitals listed. This is the main entity. It's their money. These folks were involved with it. He's the chief investment officer. That's such a direct relationship, as I said. I think it's on steroids. He's a servant. He's someone they're a partner. All of these things, that it simply can't be that we should tolerate that. Can you imagine what it would have been that if Advocate became aware that this officer of the place they're investing in says fines against them in a multi-million-dollar way? Would they pull their money? You know, if I'm using that firm and they vote against me, I'd pull my money. Would Advocate? Would you not? We would say that they would. Talk about sleight of hand. What you're seeing sleight of hand-wise is the shell game being played at page 18. Don't be misled. Those names are related companies. They're not separate, as they tried to describe. That same word, separate, is used at page 18, as was used by Ms. Dial at the trial level, where it said, oh, they're separate. That was the whole idea. Separate this endowment from the medical group. And it never was separate. It's always been about the parent. That's there. It's there to be seen. We say, when you can do so for justice, this court has taken sua sponte judicial notice. We tried this at the trial level, at the appellate level. It was declined. We're asking the court to take a good look at that, because that will get justice for Tom Ittersagen, and it should. The reality is, after the trial court was misdirected, after the appellate court was misdirected, these misdirections were never corrected. No one came forth and said, oh, there's not an endowment, until we caught him on it here before you. That's what I think happened. And that's why they went to page 18 and said what they said with listing other entities named at Advocate. They want you to look elsewhere. Don't look at that man behind the curtain. That's where they are in this case. And we believe he did not get that unbiased jury that we care so much about in this country. Look closely at that transcript. I agree. He looked at the page 1887, I think Your Honor pointed out, Justice Burke, you pointed out the fact that he said no on that one. But he was coming back to clarify. And he was interrupted by Mr. Williams first, but then the wait stops and the misdirection, she moves right in, and I'm sorry, but that's what happened. And he goes on to push back on the fiduciary relationship. Those aren't words thrown into his mouth. He says it. No, but we have a fiduciary relationship. No, I have a fiduciary relationship with the endowment of advocate. Your Honors, this case turned for a long time on phrases that the lawyers' representations were in court, and that's where rulings ultimately came. They created a thing, and it's never been corrected until just now. As I've said, there was never an endowment. Our fiduciary relationship most certainly is involved there. It's about money. It's about investments. It's about earnings off of it. It's about advocate growing hospitals. And when he said that word about they build hospitals, they own hospitals, it is this advocate. And we ask you to provide us a new trial. Thank you.
Thank you, Mr. Smith. Case number 126507, Thomas Ittersagen versus Advocate Health and Hospital Corporation, is taken under advisement by this court as agenda number 11. Thank you, Mr. Smith, for your argument this afternoon, and also Mr. Larson for your argument this afternoon.